thank you very much for having me. My name is Benjamin Miller. As you may have heard, I'm a staff lawyer at Community Legal Education Ontario. We're a legal aid clinic, part of Ontario's legal aid system. In contrast to other legal aid clinics, we do not provide one-on-one legal advice or representation, so I cannot review your bylaws. I cannot provide advice specific to your situation. We provide general education that I hope you'll find is plain language, practical, and accurate. Now, I'm just a small part of CLEO, the nonprofit law section. We do employment law, housing law, settlement, services, social security, you name it. These resources may be useful to your staff, your volunteers, or your clients, and we actually provide training for frontline workers on how to better connect their clients with legal information. So if you find your frontline staff are getting a lot of legal questions and you don't know what to do with them, we actually provide supports for that. So, Ontario's Not-for-Profit Corporations Act. I'll begin with what the heck that is. You're in the room. Yes?
And before you start, may I ask, are we going to get a copy of your presentation? Or...
Yes, absolutely.
Okay, thank
you. Everything will be provided afterwards. There are also recordings of very similar sessions online. I don't think this particular session is being recorded, but you can, or maybe it is. So you can get access to that recording and many other recordings online of other sessions related to similar topics. There'll also be follow-up for links, and if there are any questions I can't answer today, I'll endeavor to do so in a follow-up email. And a note about questions, feel free to ask them at any time. This presentation is the result of countless questions, literally something like over 2,000 questions, at sessions before, or sessions we've received from the public, etc. So this is really just, it's not me, I'm not the sole author. This is authored by countless nonprofits in Ontario. So Ontario's Not-for-Profit Corporations Act. So you're in the room, so you probably have an idea of what it is. It's a statute, a corporate law statute, so it applies to things like who's on your board, what records you need to keep, how do you take votes, online meetings, in-person meetings, etc. That's the type of thing that it applies to. It replaces Ontario's Corporations Act. So if your organization was previously incorporated under Ontario's Corporations Act, you automatically came under Ontario Not-for-Profit Corporations Act. You didn't have to do anything. It happened on October 19, 2021. There's one exception to this, which is share capital social clubs. Any share capital social clubs here today? All right, that simplifies things. So they needed to actively do something, but that's not your case, if you're not one of them. It applies to provincial corporations. Beyond just Ontario Corporations Act, it also applies to Special Act corporations. Any agricultural or horticultural organizations here? Okay, that also simplifies things. All right, we're doing well. It doesn't apply to unincorporated groups. So if you're unincorporated, you actually do not need to be here for today's session. If you are federally incorporated under the Canada Not-for-Profit Corporations Act, this session doesn't apply to you. You don't need to worry about ONCA. Okay, so if you're federally incorporated, you don't need to worry about both. Okay, so that's ONCA in general and who it applies to. The goal of today is to do three main things. Number one, I'm going to highlight for you the broad changes under ONCA, the kind of biggest differences, but I'll tell you right now, it's actually by and large very similar. It's not going to turn your world upside down or inside out or anything like that. Number two, I'm going to cover the general steps to bring your organization into compliance with the ONCA. And number three, I'm going to discuss briefly a few resources that we have on our website that are free. Who here has been to CLEO's nonprofit law website before? All right, so for those of you who haven't, this is your first, if you take nothing else away, nonprofitlaw.cleo.on.ca, and that'll be shared again after this session. Lots of information that we're not covering here today on there, and I'll talk about that a bit at the end. So before we get started on any of that, I want to make sure we're all on the same page. And I'll do this by explaining some key terms that I get lots of questions about on a regular basis. So if you have questions about these key terms, please do ask them, because you are definitely not alone. So 2 sets of key terms to make sure we're all on the same page. Number 1, governing documents. What do I mean by governing documents, and what sort of governing documents are there, and what does ONCA apply to? Number 2, different roles within your organization. So I'm going to jump ahead to the key terms. Oh yeah, I would be remiss if I didn't mention the funder, the Law Foundation of Ontario. Can't forget that. And the Ontario Nonprofit Network are dear partners in all this work. We'll get to the disclaimer. We're actually going to work backwards. So key terms. So governing documents. So broadly speaking, there are 3 types of governing documents. There are your letters patent, now referred to as your articles. This change in terminology doesn't require you to do anything. You don't need to cross out letters patent and write in articles on your document. You don't need to file anything with the government. It's just a new term. So I'll be using the term articles. You should know it's referring to your letters patent. Type of governing document number 2, bylaws. You may have a different name for it. You may call it your constitution. You may call it your governing rules. You may call it your community covenant. You may have any number of names for it. A rose by any other name would smell as sweet. This is the document with your rules of governance in them. Who's a member? How do we vote? When does the annual general meeting happen? Where are headquarters? All that kind of thing. If that kind of information is in one document, regardless of what you call it, chances are from a legal perspective, it will be considered your bylaws. So when I'm referring to bylaws, I'm referring to that document, whatever you may call it. And then finally, number 3, policies. Nonprofits have tons and tons of different policies. HR policies, confidentiality policies, safety policies, admission policies, you name it, there's a policy for it. Policies, in contrast to bylaws and articles, are more operational. They tend to be more detailed, and there's a lot of flexibility about how you create them and change them. ONCA does not really have anything directly to say about policies. So today, we're really just concerned about the first 2 categories, your articles and your bylaws. So a bit more on those 2. Articles. So your letters patent or your articles is the document that the government would have first sent you when you became incorporated. It would have the name of your organization, its official legal name, not just the name you go by, your registered address, your purposes, and any special provisions you may have asked to put in when you became incorporated. Don't worry if it's a short document. I sometimes get panicked emails from the public saying, oh, my letters patent is short. Am I missing something? It's okay. Just because it's legal doesn't mean it has to be long. You can have a short letters patent. So that document you would not have created. It was sent to you by the government. In contrast, your bylaws are a document that you would have created. And you may have multiple versions from them. Yes?
What if you don't have like a corporation? Been around for 50 years and people that started this aren't here anymore and all that stuff is gone.
Great question. Great. So the answer to getting articles is actually really easy. And this is one of the best things about the new online system that we are going to talk about, the Ontario Business Registry. So if you go online and you Google Ontario Business Registry, and you click on the link, the first link that doesn't look suspicious, it looks like it's actually from the government. You click on that link, you go to the Ontario Business Registry, and you search your nonprofit, according to its official legal name, not just the name you go by. You click, it should come up, you click on it, and you'll see some basic information that the public has access to. In the top left corner, there's a button that says Order Search Products. You click Order Search Products, it'll give you an option to order from the government, order it from a third-party company, and it'll give you different things you can order. One of the things you can order is a profile report, which will tell you who the government has on file as your directors, as your address. Great thing to order. Make sure the government has the up-to-date information on file. A second thing you can order is called archive documents. A very unhelpful name. Basically, it's everything the government has as far as your corporate records go on file. It would include your articles. If you ever made changes to your articles, it would include that. It would include past filings you made, annual filings, changes to your corporate records, etc. It's a wonderful walk down memory lane. If anybody here has a 50th anniversary coming up or 75th anniversary, order one of these packages and make some kind of slideshow out of it because it's a lot of fun. You look at all these names like, oh, I haven't seen him in 30 years. Oh, that guy's dead. He's dead for sure. And the best part of it is $3.50, which in my opinion is even better than free because it's like you had to pay something, but it was such a good price. So that's what I would say to that. That's a great place to start if you're wondering where to begin the process. Okay, so those are some of the governing documents. And what I will mention actually though is if you don't have bylaws, that's more complicated. The government would not have your bylaws on file unless you're a registered charity. If you're a registered charity, you can go to the Canada Revenue Agency website and you can order the last copy of the bylaws that they have on file. If they don't have bylaws on file, you can check. If you work with a lawyer, you could ask that lawyer. Maybe the lawyer's office might have records, etc. Maybe your funder or your bank or somebody may have asked for a copy at some point. They may have it on record. If you can't find it anywhere, it becomes complicated. What are the rules that apply to you? If you think you never had bylaws, then it's a bit simpler because automatic rules apply under ONCA if you never had bylaws. But if you think you did have bylaws and you just can't find them, then you basically have to assume that you need to follow the most stringent rules under ONCA because you can't be sure what your rules are. And so once you try to change your rules, you have to do so according to the highest possible standard. So, for example, it might be, your bylaws might say that you need to decide things by consensus, right? So if that happens to be what your bylaws actually said, you better have achieved that threshold to change it to something more practical. Now, if that doesn't sound realistic to you, you can also seek legal advice, and there may be workarounds. Our website, one of the things our website has on it is a directory of lawyers that work in this area. We don't vet or recommend anybody, but we do confirm that some part of their practice includes nonprofits. So that's a situation where a lawyer might be able to help. Okay, so those are the governing documents. When it comes to the key roles in your organization, obviously lots of different people, lots of different types of people make a nonprofit work. But from a legal perspective, there are really three crucial roles from a corporate law legal perspective. They're your members, your directors, and your officers. And what I really, really want to emphasize is that although these are different roles, they can be filled by the same people. And even if they're filled by the same people, they are three different roles. They have three different sets of rules, they have different powers. So just because the same person may be filling more than one of these roles does not mean you could say, well, our directors and our officers are the same people, we don't need an officers section. Our members and directors are the same people, we don't need a members section. It doesn't work like that. You still need to follow the rules for each distinct type of role, even if it's the same people. Okay, so what are these roles? So members. Members are to nonprofits as shareholders are to for-profits. What does that mean? It means ultimately the nonprofit answers to its members. Well, you may say, firstly, we can't get them to show up to anything. Secondly, I don't even think we really have members. Thirdly, even if we had members, we wouldn't know who they were. We haven't had a list in decades, right? Very common situation. So if you don't know who your members are, then the first place to look is in your bylaws for a definition of membership and just see who meets that definition. If there is no definition of membership in your bylaws, look through past versions. If there's no definition there, look in the minutes of board meetings and members' meetings. If there's no one appointed as a member there and no definition was ever passed, ONCA says that in that case, if you really have no definition, then the members are the people listed on your articles, on your letters patent as your founding directors, and then anyone appointed as a member by the board. Now you may say, oh, the people on the articles, well, this one's dead, this one wants nothing to do with us, right? This one would love to come, but we don't want to talk to him, right? It can be difficult. So if you truly can't find any members, at that point there's a process to go to court. That would be a situation in which legal advice would be warranted. But most of the time people can find some kind of member somewhere in their corporate history, and you only need one. You only need one person who you can legally claim this person was a member, and so we got members' approval to make changes, to change your definition of members, to bring in more members, etc. And then you can kind of hit the reset button on your membership. So that's members. Members have very important powers like electing the directors, removing the directors. Their approval is required to make changes to your bylaws, so that's going to be a really important step in the ONCA transition process. Their approval is required for major decisions like sales of assets, mergers, changes of name, etc. Next, your directors. You may refer to this as your board, or a bit confusingly, the members of the board. Members of the board and members of the corporation are not the same thing, so to avoid confusion, I'm just going to refer to the board as the directors, or the board of directors. The directors are collectively responsible for overseeing the organization. The buck stops with the board. That's basically their job, to be responsible. And they're voted in, for the most part, by the members. Contrast that with your officers. Very often, nonprofits use the term directors and officers interchangeably. They are not the same term, although they may be, both roles may be filled by the same person. You could have someone who's a director and also the president, someone who's a director and also treasurer, etc. The difference between directors and officers is that directors exercise oversight of the organization collectively. They exercise their power collectively through board resolutions. If you've got a director walking into the office and calling the shots, that's a problem, right? The individual as a director does not have individual powers. Their power as a director is collective. The board has the power. Officers are different. Officers, whether it's a chair, secretary, vice president, you could dream up any name you like. Officers are people who have been given a specific job to do, and they're given the powers to do that specific job. Officers, unlike directors, are not elected by the members. Officers are appointed by the board. However, you can change that if you want in your bylaws. You can say in your bylaws, our officers and directors are elected at the same time, both by the members. Okay, so with that kind of foundation in mind, a few disclaimers, and then we'll jump into those three things I promised. So disclaimer number one, and I've already alluded to this, today is general legal information, it's not legal advice, which means I can't tell you what to do. I'm not going to use prescriptive terms generally. Number two, today's an overview of the ONCA. It doesn't cover other areas of law that may affect you. For example, there's charity law to think of. I will flag how charity law comes into play in a few different places, but by and large, we are just talking about the ONCA. And then finally, today's about law, it's not about best practices. A lot goes into good governance, much more than the law. There's psychology, there's history, there's culture, there's politics, right? So just because you're following the law doesn't necessarily mean you're doing a good job of governance. That's the first thing to keep in mind. Your stakeholders in your organization may expect all kinds of things from you. They may have a right to, or they may not. But they are perfectly entitled to ask whatever they want. It's up to you to decide, are you going to give them what they want? But don't think just because, okay, we met the minimum standard of the law, we're golden, right? It's just a minimum standard. Okay, so I'm going to put this away for a moment and move on to the first part of the presentation where we're going to talk about three things, three big differences in the ONCA. And I've already mentioned the ONCA is, and by the way, ONCA is short for the Ontario Not-for-Profit Corporations Act. I should spell that out. I mentioned the ONCA is not a world of difference. There are a few areas that we're going to talk about. I'll also mention there are no ONCA police. Okay? It's nobody's job in the government to knock on your door and ask you, have you complied with your bylaws? So the question is, why even bother? Right? So there are many good answers, I think. It's a way of fostering a culture of procedural compliance, of fairness, of transparency, and so on. It creates a sense of consistency. It gives you a framework for dispute resolution when disputes inevitably arise, and so on. But the way ONCA is actually set up when it comes to enforcement is certain people in your organization, members, directors, officers, in some cases lenders, have rights to take your organization to court if they think you're not following the law. This rarely happens. To give you a bit of context, so there are about 58,000 nonprofit corporations in Ontario. I've done a search, and in the last 20 years I could find about a few dozen publicly recorded cases on nonprofit corporate law. Okay, over more than 20 years, right? For 58,000, just a few dozen. That is, so it's not very likely right? That these things are going to be resolved in court. It's likely that issues will come up, but they're probably going to be resolved through relationship, through discussion, or not resolved at all, and there'll just be a simmering tension for decades. That also happens. But I encourage people to think of this ONCA transition process not as something like, ooh, I'm afraid, we're anxious, we're intimidated by the process. Instead, it's an opportunity to really renew your governance, ask yourself, does the way we make decisions still work for us? Okay, so with that in mind, three big differences. The first difference between ONCA and the previous act is this concept called a public benefit corporation. So it used to be that all nonprofits faced the same set of rules. Charities had a bit different, but they, by and large, had the same set of rules under Ontario Corporations Act. Now under ONCA, all nonprofits face the same set of rules, but then some nonprofits face some additional rules. Who are these nonprofits? What are those additional rules? These nonprofits are called public benefit corporations. So I'm going to talk about who qualifies as a public benefit corporation and what are those additional rules. So there are two ways that your organization could be considered a public benefit corporation. Number one, if you're a charity, you're automatically a public benefit corporation. So that's pretty simple. Number two, if you're not a charity and you're wondering, are we a public benefit corporation? The question to ask yourself is, last year, did we receive more than $10,000 from any of the following sources? Grants or financial assistance from government. And when I say government, I mean federal, provincial, municipal government, or an agency of government. Or gifts or donations from individuals or organizations who are not our members, directors, officers, or employees. Don't worry if you're not getting all this down. We have it all on the website, but it's still a fun exercise to write it. It helps memory and so on. So that's who's a public benefit corporation. And there are a few common questions I want to address because they come up all the time. So number one, did COVID relief funding count? Yes. The financial assistance, the loan part, if you got one of those, counted. Various kinds of grants, subsidies for employment expenses, etc. All that kind of stuff is what ONCA is talking about when it talks about grants and financial assistance from government. Another common question is, does sponsorship count? Now, sponsorship is not a legally defined term. So it can mean different things depending on the context. So if sponsorship means, look, somebody donated $500 and we're going to express our gratitude. And we told them we'd express our gratitude. That's really a gift. It's not that they're contractually obligated to advertisement or recognition. You're just showing your gratitude and you're calling it this gift sponsorship. In that case, it would count towards your definition of public benefit corporation. But if instead of a gift and some gratitude, you had, okay, if you give us $100 for this event, you are entitled to show up on our flyer. You are entitled to 5 minutes of speaking time at the event, right? Now we're no longer talking about a gift, we're talking about an exchange. What counts towards your public benefit corporation status are gifts, donations, grants, financial assistance, things that are being given to you, not in exchange for something. If there's an exchange going on, it doesn't count towards this $10,000 threshold. Okay, so that's who's a public benefit corporation. What are the rules? So again, largely public benefit corporations have the same set of rules as everybody else. There are a few differences. I'm going to focus on three. So number one, if your organization dissolves, that means it goes kaput, basically. It ceases to exist as a legal entity. It dies. Right? The question is, who gets the property? Well, first you have to pay off all your lenders. Once you've paid off all your lenders, who gets the remaining property? And the answer is, well, check your bylaws, check your articles. There may be what's called a dissolution clause, which says what happens to the property. And it used to be that you could put whatever you want as a dissolution clause. It could go to the members, it could go to your uncle, it could go anywhere you wanted to go. now that remains true for most nonprofits, but for public benefit corporations, there are limits. If you are a public benefit corporation and you dissolve, you can only give your property to, if you're a charity, government, meaning federal, provincial, municipal government, or an agency of government, or registered charities with similar purposes. If you're not a charity and you're a public benefit corporation, then you can give your property upon dissolution to government, federal, provincial, municipal, or an agency of government, or another public benefit corporation with similar purposes. Okay, so you're restricted in what happens to your property if you fold. Number 2, who can sit on your board? Yes.
Just quickly on that. So to give your property, if you're a public benefit corporation, a charity, your other option is to give it to an as a registered charity.
Correct.
You can't get another incorporated who's not quite registered yet.
Correct. So the question is, if you are a public benefit corporation who's a charity and you dissolve, can you give your property to someone who's not quite a charity yet? Maybe they're going to be a charity in 6 months or something. The answer is you need to get it to be a registered charity. They need to be a registered charity at the time that it's being transferred. Okay, thank you for that question. So the second area of difference is who can sit on a public benefit corporation's board. Now, I'm glad you're all sitting down because you may be surprised to find out that actually nonprofits in general, all their board could be employees, in theory. There's no law that prohibits an employee from being on the board. Now, it may not be a good idea. Remember, I told you the law and best practices are 2 different things. Your funders may see it as a red flag. For sure, I've spoken to funders who look at it that way. But there's nothing illegal about it. It's a bit different for charities. I'll talk about that in a moment. But for regular nonprofits, employees can sit on the board. For public benefit corporations, employees can sit on the board, but they can only make up to 1/3 of the board. Again, there's no obligation to have employees on the board, but it's possible. You can have employees form up to 1/3 of your board. Now, here is an area where the rules for charities are very different. So the way it works in general is that you have corporate law, and then if you're a charity, you also have charity law in addition to that. So it stacks on top. Right? And if there's any conflict between charity law and the corporate law, the charity law wins. Always follow the charity law if you're a charity. And this is an example of that. So for charities, they can only have an employee or even a contractor or anybody who's paid by them or even a relative of an employee or contractor sit on the board if they follow the rules set out in a guide called Payments to Directors and Connected Persons. This guide is published by the Public Guardian and Trustee. The guide sets out what circumstances under which it's allowed, and they're narrow. Okay, it's not just allowed willy-nilly. But even if it's allowed, what procedure you have to follow to approve it. Okay, so if you're in a situation where you're a charity and someone's on the board and they're asking, can I be paid, can I do this, can I do that? I mentioned there are no ONCA police, but there are charity police. There is the CRA, there's a public guardian and trustee, and this is a rule they care a great deal about. So proceed with caution. I don't want to say it's impossible. Some lawyers will tell you it's impossible because if you want to try, it just leads to so many complications. It's easier for them to just say it's not allowed. But it is allowed. It's just very limited, the circumstances under which it's allowed. The final area in which public benefit corporations are different from regular nonprofits is financial review. So this is who has to get an audit and so on. Now the thing I really want to emphasize is that there is no one who is now required to get an audit who wasn't already required to get an audit. The rules under ONCA are, strictly speaking, more lenient. Okay, there is no situation in which they are more onerous when it comes to finance, more onerous. Well, it may be that you haven't been getting audits, and maybe you should have been getting audits. But don't worry if that is your situation. That's a very common situation. There were no police under the Ontario Corporations Act either. Okay, so what could happen if you were supposed to get an audit and didn't get an audit? So in theory, a member, a director, an officer could take you to court and ask the court to force you to get an audit. Okay, think about who's the most vindictive person in your community, right? How likely are they to know this rule? How likely are they to want you to get an audit, right? That's really what you need to be concerned about. Most people, it doesn't matter, even if they haven't been getting an audit all this time. If they get an audit going forward, great. So they're back in the black, so to speak. Okay, so who is required to get an audit under ONCA? So by default, everybody is required to get an audit, but many organizations have the ability to pass what's called an extraordinary resolution and waive the audit at a members meeting. So you typically an annual members meeting, not necessarily. To waive the audit, and instead they may be required to get what's called a review engagement or no external review whatsoever. So I'm going to explain what's an extraordinary resolution, how do you go about passing one, what is a review engagement, how does it differ from an audit, and then who has this ability to get a review engagement or waive an audit altogether. Okay, so an extraordinary resolution. So a resolution is a motion passed at a members meeting in this case. There are board resolutions, but in this case we're talking members resolutions. So it's a resolution, it's a motion passed at a members meeting. And an ordinary resolution is a simple majority of the votes cast at the meeting. Okay, so to put it simply, 50% plus one of the votes cast in favor, an ordinary resolution passes. That's an ordinary resolution. But here we're talking about an extraordinary resolution. What makes it so extraordinary? Well, you need an 80% plus approval rate. But I want to be clear, it's not 80% of all your members in the organization. It's not even 80% of all your voting members. It's 80% of the votes cast at the meeting. So if you can pass an extraordinary resolution, and if you want to, by the way, you have to do it each and every year. You can't just pass one extraordinary resolution and say, we're never going to have an audit again. Ha ha ha. It doesn't work like that. If you want to waive an audit, your members have to actively do so every single year. So if you can pass an extraordinary resolution, you may have the option of getting a review engagement. What's a review engagement? So I'll explain it by contrast to an audit. An audit is where a CPA, chartered professional accountant, comes in, looks at your source documents, like your receipts, your invoices, and so on, looks at your financial policies, your signing authorities, your checks and balances, looks at your financial statements, like your balance sheet, your cash flow, etc. And then based on all that, they conclude whether or not they can provide reasonable assurance that your financial statements are a reliable reflection of your financial position. That's an audit. A review engagement, by contrast, is faster, it's cheaper, because it's less extensive. Still, it's a CPA coming in, looking at your source documents, looking at your financial policies, looking at your financial statements. But at the end of all this, they are concluding whether or not your financial statements are a plausible reflection of your financial position. Now, what does plausible mean? It means they didn't see any red flags. Now, if you are a small organization with relatively simple finances, that may be sufficient. If you don't have a lot of external stakeholders, if nobody's knocking on your door, demanding an audit, it may not matter whether or not you have a review engagement or an audit. So for some organizations, it may be appropriate. For other organizations, it may be more appropriate to have the more extensive audit. Okay, who has this option? So it depends on two things: your annual revenue and whether or not you are a public benefit corporation. So for annual revenue, and when I say revenue, I mean everything. I mean your donations, I mean your fees for service, I mean your sponsorship, I mean everything. If you are an organization with an annual revenue under $100,000, by default, you have to get an audit each and every year, but you can pass an extraordinary resolution, waive the audit, and you don't have to get a review engagement. Okay, so you still have to prepare the financial statements, Still have to present them to the members, but you do not need to get an audit or financial review. And it doesn't matter whether you're a public benefit corporation or not. If your organization has annual revenue between $100,000 and $500,000, it starts to matter whether you're a public benefit corporation or not. If you're a public benefit corporation, by default, you have to get an audit. But you can pass an extraordinary resolution, waive the audit, but you do have to get a review engagement. So for public benefit corporations with annual revenue between $100,000 and $500,000, they can waive the audit, do need to get review engagement. If you're not a public benefit corporation, you can waive the audit and not even get the review engagement. So up until $500,000, if you are not a public benefit corporation, don't have to get an audit, don't have to get a review engagement, as long as you can pass an extraordinary resolution. Finally, if you're an organization with annual revenue above $500,000, if you're a public benefit corporation, you have to get an audit each and every year. The rule hasn't changed for you. So for this group, there's no difference, before or after ONCA. If you are not a public benefit corporation, by default, you have to get an audit. You can pass an extraordinary resolution, waive the audit, but you have to at least get a review engagement. Okay, so moving on to the third and final difference that I'm going to highlight under ONCA before we move on to how do you actually go about transitioning, the Ontario Business Registry. So we've already talked about this a bit. The Ontario Business Registry is online, and people sometimes ask me, do we have to sign up? No, you don't have to sign up as such. All the corporations are already on it. However, if you want to gain access to it in order to make changes, you need to get what's called a company key. And you do that by going on the Ontario Business Registry website, and you scroll down and there's a button, order a company key, and they're going to send it to the address that they have on file. This is why it's important that you make sure, by ordering a corporate profile, that they have the right address on file. What do you do if they don't have the right address on file? So unfortunately, it means you're going to have to work with a third-party provider who's going to charge an additional fee. Last time I checked, it's depending on which provider you go with, it's between $150 and $225 to update your address. It's a lucrative business if anyone's looking for a new line of work. So you'd update your address. Once you've updated your address, you can order the company key and deal directly with the Ontario Business Registry. And once you're dealing directly with the Ontario Business Registry, many services are free, and some do have fees.
They let you guess as many times as you want.
Do they let you get? So good question.
We just
Yes.
went through it. We just went through it.
Yeah.
And it took on our 5th try.
Yeah.
We got it right.
Yeah. There's no security, so you can keep guessing.
Yeah.
The other thing is you could put in, anybody can order the company key. So if you're looking to play a prank on somebody, you can order lots and lots of company keys and to a particular address. You may have no connection to the organization. Every company key you order is going to cancel the last one that was sent. So if you've got multiple people in your organization working on this, one tip is make sure only one person's ordering the company key, right? Unless, of course, you want to play a practical joke on the other person. Funny for some people, I guess. Okay, so what can you actually do on the Ontario Business Registry? So you can file your annual report telling them, has anyone changed on our board? Have any of our officers changed? Has our address changed? That does not replace any filings you need to make with the CRA. So if you're a registered charity, you still have to file your T3010, which is your annual information return. So the Ontario Business Registry doesn't replace that. It's two different systems. You can also do things like change your name. You can change your articles, which you might need to do as part of the ONCA transition process, which I'll talk about in a bit. And you can make changes to the address, the names of your directors, officers, and so on. So it's got lots of options once you're in, and they're making the system better all the time. When it started, there were a bunch of glitches. They've been working with the Ontario Bar Association to improve. They have made improvements, I'm happy to say. So it's a work in progress. So that's the Ontario Business Registry. So that brings me to the end of that first section, the big differences with ONCA. Are there any questions at this point? All right. So moving on to what do you actually need to do to transition to the ONCA. So I'm going to highlight 6 steps. Step number 1, figure out if it applies to you. Now, I've already talked about this. It applies to provincial corporations, like those incorporated under the Ontario Corporations Act and those incorporated under certain special acts. Doesn't apply to federal corporations under the Canada Not-for-Profit Corporations Act. Some details that I'll add now. Doesn't apply to co-ops incorporated under the Cooperative Corporations Act. Doesn't apply to condos that are incorporated under the Condo Corporations Act. Now, if you're in a housing nonprofit that you call a condo, it may still be a nonprofit incorporated under this act. So check which act it's actually incorporated under. And I mentioned it doesn't apply to unincorporated groups. Later we'll be having a session for unincorporated groups, and we'll talk about this law, but in a way that's more relevant to them. So that's who it applies to. So you figured out, okay, great, it applies to us. What is our timeline? So ONCA took effect on October 19th, 2021. And what I mean by took effect, it started applying, its rules started applying. But for organizations that were already incorporated, there's a 3-year transition period until October 19th, 2024. During this 3-year period, your governing documents, so your bylaws and your articles, continue to be valid as long as they were valid before ONCA took effect. Even if the rules in your governing documents conflict with ONCA, it doesn't matter, they keep being valid. So it's like there's a bubble, a protective bubble around your governing documents. So the first place you look for the rules of your governance is in your governing documents. If a situation comes up, you look in your governing documents, you can't find an answer there, now you're looking into the ONCA for an answer of what is the rule that applies. So that's what's happening during this 3-year transition period. What is going to happen at the end of this 3-year transition period? Well, no organization is going to disappear. You're not going to poof out of existence. There aren't going to be fines. No one is going to drag you off to jail. Nothing like that. Much, much less dramatic. What will happen is at the end of the 3-year transition period, your rules will be considered by ONCA to be automatically transitioned over to be ONCA compliant. So what that means is any rules in your governing documents that aren't quite compliant will be changed in some way. So what does that mean practically? It means that if you haven't made any changes and you're looking at your governing documents after October 19th, 2024, you may not be looking what your true rules are. From the legal perspective, the rules may be different than what you've actually written down on paper. So that's a confusing situation. So to avoid that confusing situation, you may want to complete the transition process before October 19th, 2024. But even if you don't, it's okay. It just means you're going to have to figure out what are our rules after October 19th, 2024. But it's all still possible. Okay, so that's your window. How long does it actually take to do the work? So lawyers that work in this area, I've heard, give estimates of about 6 to 12 months. It could take shorter, it could take longer, but that's the normal range. There are 4 main variables that I've seen in organizations that could cause it to take longer or shorter. Okay, so factor number 1, when was the last time you looked at your governing documents? If it's been decades, chances are there are more things that you need to change than just what ONCA requires. Language may be out of date, it may no longer reflect the activities or purposes of your organization, you may have a totally different governance structure, etc. Okay? It's quite common in that situation. It takes a bit longer to do the transition as a result. More to think through. Number 2, capacity. Now when I say capacity, I mean a few different things. Do you have money to hire somebody to do this? That's factor number 1. And I'll talk a bit more about that in a bit. Do you have people on the board or among your volunteers or among your staff who are comfortable doing this work? Right? If they're not comfortable or if they're not familiar with your governing documents already, there's going to be a bit of a learning curve. And that takes time. But I actually think this is part of the advantage of the ONCA transition process, that it forces us, if we want to comply, it forces us to educate ourselves about our governing documents. So yes, it takes a bit longer, but I would encourage people to see the positive nature of this learning opportunity. This is a way to build capacity on your board and sensitivity to your rules. Number 3, consensus. So I've sometimes seen it where the ONCA transition process kicked up the dust on issues that have been long dormant in organizations. In one case, it was an issue dormant for literally 80 years. So, there are fun stories that happen as a result of fun for me, it wasn't fun for them. Fun stories that happen as a result of the ONCA transition process. Ask yourself, do we have agreement on the board of how we make decisions? Do we have agreement among the membership? Do we have agreement between the board and the membership? If the answer is no, it means that you're likely going to have to spend more time building consensus. This is not a bad thing. Decisions that are made after the time has been taken to build consensus are A, more likely to last, so you're not going to have to redo this in a year and another year and another year. B, are more likely to be followed. And if you take nothing else away besides the website from today's session, I hope you take away the following. Complying with the ONCA is not just about what you write down in your governing documents. It's how you take what you've written down in your documents and you actually implement it in practice. So if you write things that sound good to a lawyer but are meaningless to the people who actually have to live with the rules, they're not going to be followed. And the most compliant set of documents in the world will not actually result in compliance in your governance, right? If, on the other hand, you take the time to talk to people who are going to have to live with the rules, you build agreement, you work through disagreements, you think about the different values and principles and practicalities and so on, and you come up with a set of rules that make sense for you, not only is that more likely to be understood, more likely to be respected, seen as a legitimate process, and therefore less controversial, but ultimately it's more likely that it'll be followed. And that is what true compliance is. The final major factor, I'd say, in the timeline is how easy is it for you to have membership meetings. If it's like pulling teeth for you to get anybody to come out to a membership meeting, then you may need to wait until your next annual general meeting before you can finally approve the changes that you drafted in the meantime. So that causes some delay. But if it's relatively easy for you to have membership meetings, let's say you have a small membership or your board and your members are the same people, so it's relatively easy, that speeds up the process. Now the last thing I'm going to comment on in this section of timeline is working with a lawyer. So I get lots of questions about working with a lawyer, and I've actually written a blog article on this topic for the Ontario Nonprofit Network called Taking Ownership of Your ONCA Transition Process. And so I'll answer a few of the most common questions. So number 1, do we need to work with a lawyer? The answer is no. There's no legal requirement that a lawyer has checked your bylaws, checked your articles. There may be advantages. It may help to resolve certain complexities or ensure compliance, particularly if you're a registered charity or you have major assets or you have a complex corporate history. A lawyer may be able to provide some value in terms of sorting all that out and minimizing risk. Whether that value is worth the cost is a different question, but they may add value. But there's no requirement to work with a lawyer. Number 2, when it comes to working with a lawyer, people ask, where can we find one? How much does it cost? What can we expect, etc. So where can you find one? So I mentioned there's the lawyer directory on our website. Again, we don't try to recommend anybody. They confirm they work with nonprofits. In terms of how much it costs, so one prominent lawyer in the field, and I give him much respect for his level of transparency, said that on average, a full ONCA compliance, so the Rolls Royce of ONCA compliance, costs about $5,000 to $15,000. Now, you may be a bit blown away by that number. I certainly was impressed by his willingness to state it publicly. I think there are really 2 things to highlight here. Number 1, ONCA compliance is not all or nothing. What he was describing was really some client comes to him and just says, here, do it. Just do it for us, right? That can be a lot of work. A lot of time is spent just sorting through your records, getting them straight. That's time that's billed at a certain rate that maybe you could just get a volunteer to sort through your records, right? That takes off a slice of the time. People come with big questions, just say just make it compliant. answering that question is much more exploratory and bigger in nature than someone who comes with a very precise question and they want a very discrete answer, which sometimes a lawyer can just give off the top of their head, especially one that practices in this area and sees it a lot. So the more work that you do to get your records in order, to understand the law so that you can know what precisely is a complicated issue for you and what is less risky and you can probably figure out yourself, right? All of that brings down the time it will take if you do decide to work with a lawyer to work on this, the time and therefore the money it will take to work on this. There are also factors like where is the lawyer based, is it a big firm, a small firm, etc. So, do shop around, get a few quotes. You'll see it does range considerably. Also, the seniority of the lawyer matters a great deal and so on. As I mentioned, I think one of the, there are two things I mentioned that I'd like to bring back here. So number one, compliance is not about your documents, it's what you do in practice, right? The lawyer, even if they're a great expert, right, they'll be able to generate a compliance of documents for you, but unless they happen to be very familiar with your culture, with your history, with why you do things the way you do, it's unlikely that they are going to develop a very customized set of bylaws that really reflects your day-to-day realities. That's something that really only you can do for yourselves. The second thing is, at the end of the day, compliance is about what you do. So you need to understand it. So simply farming it out to somebody else to do the work for you, it can save you time up front, but down the line, are you going to understand what they did, why they made the changes, what the changes were, etc. And if you don't understand, that's going to firstly take longer over time, and reduce the likelihood that you're ultimately compliant. Okay, so once you've figured out your timeline, you've figured out the work, what actually does the work consist of? So firstly, get your records straight. Okay, I've spoken to some lawyers who say that's 90% of the work, especially if you're in an old organization, right? Just being able to put it in chronological order is enormously important. A lot of what lawyers do is it seems like untangling. It's sort of like a mystery. You're untangling a story and you're trying to put it in order. So what records do you need? So number one, you need your letters patent and your supplementary letters patent. So if you ever made changes to your letters patent, you would have ordered that from the government, and they would have sent you a supplementary letters patent. It's sort of like an addendum. Okay, so they wouldn't have sent you a new letters patent, they would have sent you this additional document. You need your minutes. What minutes does ONCA require you to keep and to have? 4 types of minutes. Your board minutes, your members meeting minutes, your board committee meeting minutes, your member committee meeting minutes. How far back do you have to have them? Okay, well, I'm glad everybody's sitting down. The answer is you have to have all your minutes. Oh, who has all their minutes? I don't know. But legally, in theory, remember there are no ONCA police. ONCA wants you to have all of your minutes. Incidentally, for the registered charities in the room, the charities director also wants you to have all of your minutes. If you don't have all your minutes, what can you do? Well, if you think it's worth the time and effort, you can try to reconstruct your minutes from whatever records you do have. But if ultimately that's impossible or it's not worth the time and energy, just remember there are no ONCA police. Okay? What's the risk if you don't have minutes? The risk is essentially that if a legal issue ever comes up from that time, those minutes would have been helpful to have as evidence to prove, for example, that you did your due diligence. That's an example of how you might use minutes in a legal context. If there wasn't any highly risky activities at that time, not a great likelihood of being sued, etc., it may never matter. Someone may never ask for those minutes. But that's why it's important to keep the records. You're also, under ONCA, required to keep a register of directors, officers, and members. Now, register is just a fancy legal term for list. The list needs to be kept going back 6 years. Okay, so your current and former members, directors, and officers going back 6 years. What information do you have to have on these people? Number one, their names. Number 2, their start date. Number 3, their end date, if they're a former member, director, or officer. Number 5, their, did I say 4? Name, start date, end date. So we're number 4. Number 4, their address for service. Now, this is not necessarily their personal address, and indeed there may be some confidentiality concerns or privacy concerns around you having their personal address that they may raise. The address for service is the address where that individual agrees to receive official documents from your nonprofit. The address may even be the nonprofit's address, and that would basically be them agreeing to pick up any official documents at the nonprofit's address. Their email address, if they agree to receive documents electronically, so that's number 5. And then finally, if you have multiple types of members, or if you have multiple officer positions, the what kind of member that member is, what kind of officer that officer is. Okay, so you're required to have this register. You're also required to keep director consent forms. These consent forms are basically people agreeing to act as directors of your organization. Why do you need such a form? Well, just think about it. If you didn't require such a form, you could elect anybody to be a director of your nonprofit and tell them 4 years later, right? You could elect Nicolas Cage to be on your board, then 4 years later say, hey, Nick, you've been liable this whole time, ha ha ha. Or insert your favorite celebrity. I've tried different people, Brad Pitt, Leonardo DiCaprio, I don't know who people like these days. So you need a director consent form. It doesn't need to be a complicated form. It just needs to say, I so-and-so, so the name of the person, agree to be a director of such and such organization, so the name of your organization, as of X date, so the start date when they start being a director, the address of that individual, so we know which individual we're talking about, and then their signature. Some organizations, if you were to talk to a lawyer, for example, and you ask them for a template, they might tack on a bunch of other things to the consent form, which you might want to do. You might get them to agree to a code of conduct or a confidentiality policy or something else. You're welcome to do this, but from a strictly legal perspective, what's required, it's just that simple form, them agreeing to be a director. Now, what happens if you didn't get this consent form? Right? So this kicked in on October 19th, 2021. Does it apply retroactively? So thankfully, ONCA says if you don't have a director consent form, you can get one signed and it's retroactively effective. So if you want to fix this, you can just fix it. If you don't get a director consent form, what is the risk? Well, practically speaking, I'm not exactly sure, because if somebody has been acting like a director, if they've been attending meetings, if they've been voting on things and so on, it's going to be very hard for them to show up in front of a court and tell a judge, actually, I shouldn't be liable because I didn't sign a form, right? Courts are quite practical when it comes to this kind of thing. If it looks like a duck and it quacks like a duck and it talks like a duck, it's probably the director of a not-for-profit corporation, right? And then finally, you might want to know your annual revenue in order to know, are we a public benefit corporation or not, and what sort of financial review do we need? Okay, so those are the records. What are the actual changes you might want to make? So I'm going to give 5 examples of changes you might need to or want to make in your bylaws, and 5 examples of changes you might need to or want to make in your articles. So in your bylaws, the following may apply. Number 1, previously under Ontario Corporations Act, nonprofits were required to have a president and a secretary. Nonprofits are no longer required to have a president and a secretary. You're still welcome to. You don't have to get rid of the positions if you don't want to, but you don't have to have them. Now, nonprofits are required to have a chair. Note, the title has to be chair, not chairperson, not chairman, not chairman. The system is going to reject it. Super annoying. Also, I should mention also the French equivalent to chair. The chair needs to be a director. Other officers in your organization do not need to be directors unless your bylaws say they do. But the chair has to be a director. Now, if you already have a president, it could be as simple as just naming them chair as well. So you don't necessarily need to create a new person with a new title. As long as your bylaws don't say that one person can't have more than one title, you could have a president slash chair. Example number 2. Under ONCA, corporations can be members of nonprofits. Why would you want to do this? Well, it could be a fundraising strategy to collect membership fees from local businesses or other nonprofits. It could be a way to build accountability. Let's say, for example, that you are championing anti-racism work or reconciliation work, so you want to build a formal governance relationship with a local indigenous organization or a racialized serving or led organization. You can do that through your membership structure. Not required, but an option. Thirdly, members have the right, if members who control 10% of the votes in your organization get together, they have the right to go to your board and demand that a members' meeting be called. And the board has to call the members' meeting, except under certain exceptional circumstances. Now, this is a rule that applies regardless of what you say in your bylaws or your articles. But if you like, you can make this right easier to exercise in your bylaws. So in the ONCA, it says 10%, members who control 10% of the vote. But you can say members who control 5%, or members who control 1%, or even a single voting member could come to the board and demand a meeting, right? It's up to you. It's all about how much participation do we want to encourage versus how disruptive might this be, right? How feasible is it? Number 4, proxy voting. So so firstly, I'll explain what proxy voting is. Proxy voting is where an individual cannot or does not want to attend a member's meeting, so they appoint somebody else to attend and vote on their behalf. Under ONCA, by default, proxy voting isn't allowed. If you want to allow proxy voting, you have to set that out specifically in your bylaws or your articles. And then number 5, if you have multiple types of members, okay, what's referred to as multiple membership classes. For example, let's say you're a little league and you have the players are members and the parents are members, or the coaches are members and the players are members or something. They could have different rights. Some could be voting members, some could be non-voting members. If you have multiple voting members, ONCA wants us to be explicit about the rules that apply to each distinct class in our bylaws. So for each membership class, you need to say how someone can become a member, how somebody leaves being a member, and if and whether and how membership could be transferred, if someone could transfer between classes of membership. So these are examples of things that might change in your bylaws. Yes?
Just a question, you mentioned proxy voting.
Mm-hmm.
Can you vote electronically?
Great question.
By telephone?
Yes. So the answer is yes, and the ONCA was actually recently changed to make this abundantly clear. By default, under the law, you're allowed to vote physically in person, electronically, by mail-in ballot, by phone, telephonically, if you like. All of this is allowed unless your bylaws or articles either explicitly or implicitly prohibit it. So you probably want to look through your governing documents with a fine-tooth comb and say, does our language in any way implicitly rule out virtual voting or telephone voting? Interestingly, under ONCA, the term in person, unless you define it otherwise in your bylaws, the term in person actually includes participating virtually and by phone. So these are some of the things that might change in your bylaws. What about your articles? So the first thing that might change in your articles are your purposes. Not because ONCA actually requires you to change your purposes. It doesn't in any way. But particularly if this is the first time you're looking at your articles in many decades, it's quite likely that after you've blown off the dust, you'll say to yourself, wow, when did we ever do this, right? Or like, we do not do that anymore, or I can't believe we ever used that language. right? So you may have changes to make to your purposes. If you are a charity, changing your purposes can affect your charitable status. So this is an area where it's worth talking with a lawyer who's knowledgeable in charity law. A second thing that might change is membership. So if you have multiple membership classes, previously you could just set that out in your bylaws and it would be fine. Now if you have multiple membership classes, ONCA wants that to be put in your articles. You don't need to provide all the details, but you do need to set out, we have X number of classes, these are the titles of each class. Voting class 1, non-voting class 2, whatever it is. Now, there's a special exception, which is if you have the multiple membership classes in your bylaws, they continue to be valid even past October 19th, 2024. So your membership structure isn't going to disappear just because you didn't move it over to your articles. However, if you ever want to make changes to your membership structure and you want to keep multiple membership classes, that would have to be done in your articles to be effective. It would no longer be valid to just make the changes in your bylaws. Two other things that you might need to change in your articles. Number one, the voting rights of members. So the default rule under ONCA is 1 member, 1 vote. Your bylaws may say something else. These people have 1 vote, these people have no vote, these people have 5 votes. That was previously fine, and it continues to be fine until even past October 19th, 2024. This is another one of those special exceptions. But if you ever want to make changes to your voting structure, and you want any of your members to have something different than 1 member, 1 vote, you have to spell that out in your articles. And then finally, another example of something that you might need to change in your articles is if you want to restrict your nonprofit's powers. So let's say, for example, you're a heritage building or land trust, and you want to say, we are not allowed to sell the land, we are not allowed to sell the building, whatever it is. In order for that restriction to be binding, it needs to be in the articles. It's not enough just to put it in the bylaws. There may be other things that you want to restrict your nonprofit from doing. If you're a religious organization, it may have to do with religion. If you're a political organization, it may have to do with your politics, etc. Okay, so that's what might need to change. What's the actual approval process? So anybody can draft these changes. As I mentioned, you don't have to work with a lawyer. You could choose to work with a lawyer. You could draft them in a committee. You could have an individual draft them. It's up to you. On our website, you'll find a bylaw builder. So it's an online interactive tool that you answer a bunch of questions and it spits out a set of bylaws, which at least for our part, the part we wrote, is legally compliant with the ONCA. So somebody writes the changes and then proposes them to the board. The board then votes on those changes. Now, when the board votes on changes to bylaws and articles, it's a bit different between the two. When the board votes on changes to bylaws, unless your resolution, the meeting resolution, says something different, when the board votes on changes to bylaws, those changes are effective immediately. Now, they're only effective temporarily until the next member's meeting, but they are effective immediately. If you want to delay that effect, you need to say so explicitly. When it comes to articles, it's different. Boards don't actually have the power to change articles. What they're voting on is proposing these things to the members, and the members ultimately vote. Okay, so your board votes. It's an ordinary vote subject to the ordinary rules of your governing documents. And then they call it, or they wait for a members' meeting. So whether it's a special members' meeting just for this purpose, or it's an annual members' meeting, it's totally up to you. But you need a valid meeting. What do you need in order to have a valid meeting? You need 3 things. Number 1, you need to send out valid notice. Number 2, you need quorum. And number 3, you need a valid vote. So I'm going to talk about each of these things. So first, notice. The notice of the meeting needs to be sent out 10 to 50 days, 10 to 50 days in advance. Your bylaws may set out a more specific number within this range. Your bylaws, if they're older, may even have a greater number beyond 50 days. And that's fine until October 19th, 2024. After October 19th, 2024, a valid notice has to be within 10 to 50 days. So it has to be sent out at the right time. The notice has to provide sufficient detail to allow the members to form a reasoned opinion about what they're being asked to vote on. Whether or not they actually form a reasoned opinion is up to them, right? You know your members better than I do. But you need to provide them sufficient detail so they can form a reasoned opinion. And then finally, the way the notice is sent out needs to be done in an individual kind of way. It's not enough just to post on Facebook or post it on a bulletin board. You have to send it individually. Now, your bylaws may set out specific rules about how notice is sent. It may say it has to be by registered mail, it may say it has to be in person, it may say you can do it by email. Whatever your bylaws say, that's the rule to follow, generally speaking. Unless your bylaws say something crazy. But I leave that to you to judge. If your bylaws don't have a rule about notice, then broadly speaking, you can send notice electronically, you can send notice by mail, you have lots of different options about how notice is sent. Once the notice is sent, then you have to actually have the meeting, right? And you need quorum for a meeting. What is quorum? Quorum is the number, the official number of members, in this case, because we're talking about a members' meeting, of voting members who need to be in attendance in order to conduct official business. Now, under ONCA, by default, quorum is 50% plus one of all your voting members. Now you may say, what, 50% plus one? We can't even get 3 people to come out. You want us to get 50% plus one? Don't worry, it's a default rule. A default rule means you can change it. You can make the number as low or as high as you like. I've been in sessions where people have told me, yes, our quorum is 1 person. I don't advise anything, right? Remember, no legal advice. But I will note that the lower your quorum is, there's a trade-off, right? On the one hand, it's easier to have the meeting. On the other hand, there's less accountability. A small group of people could, walk in and walk out with your organization, right? So that's something to be mindful of. So you have quorum, great. Once you have quorum, you then need to have a vote. Votes on changes to bylaws and votes on changes to articles are different. To pass changes to bylaws, you need an ordinary resolution. That is a simple majority of the votes cast at the meeting, 50% plus 1. To pass changes to articles, you need a special resolution. Oh, we've talked about ordinary, we've talked about extraordinary. What's special? Special is 2/3 majority, okay, of the votes cast at the meeting. Not 2/3 of all the members, 2/3 of the votes cast at the meeting. Great, so once you've passed those resolutions, the changes to your bylaws are done. You've completed the transition process as far as the bylaws are concerned. If you're a registered charity, the CRA wants you to file those bylaws with the CRA. This is not part of the approval process. The CRA just wants to have it on file. The articles, however, are not done once you've approved them. You have to then file them with the government using the Ontario Business Registry or by mail or using a third-party provider. Once the government has approved them, then you're good, you've completed the process. If you're a registered charity, you would then turn around and file those articles with the CRA. Now the final thing I'm going to comment on are the resources on our website. So there is legal information, there's the bylaw builder, there's the lawyer directory, there are different examples of membership structure if you're considering different membership structures. There is a contact us form. I will note that my project actually wraps up at the end of October and I'm expecting a baby. So I will not be available after October. So if you do have questions following this presentation, I encourage you, and I will include my email as part of my email address as part of the follow-up email. I do encourage you to get in touch with me sometime between now and mid-October to be safe. With that, I'll stop here and see if there are any questions. Thank you very much for your time and attention and for your patience.
I read somewhere about terms of your board can't exceed 6 years.
Right, okay.
charities.
Yeah. So one of the changes under ONCA is that a director's term cannot be greater than 4 years, actually. Previously, the limit was 5 years, now it's 4 years. With that being said, a person can run for as many terms as they want, unless your bylaws restrict it. Again, this is another example of there's the law and there's best practices. You know, a person in theory, and I've heard of such things, can be on a board for 50 years. But you may want to restrict it to 6 or 8 or whatever you think is appropriate. So yes, the limit for a single term is 4 years, so there needs to be an election at least every 4 years, but unless you restrict it in your bylaws, which you're allowed to do, they can run for as many terms as they like.
So you could be 4 years plus another 4 years.
That's another 4 years, yes, exactly.
And you can restrict how many terms.
Exactly.
Gotcha, okay.
Okay, so the session that's going to happen at 5 is for nonprofits that are unincorporated, learning about becoming incorporated and applying for charitable status. If you're a nonprofit who's already incorporated, certainly the incorporation part is not going to be relevant to you, but you may be interested in the applying for charitable status part if that's something you're thinking about. But a large chunk of it is about incorporation. I just don't want anyone to stay if it's not relevant to you, which probably isn't going to be relevant to you, as I hope everyone here is already incorporated. Thank you.
So this, then, how does it apply to non-profits? Like we have the National ONCA Foundation, charity board, but we also sit on the law and service groups,
Yeah.
which are considered non-profits.
Yeah.
Does this apply to them?
Okay, great question. So the ONCA applies based on where you're incorporated. So service clubs, generally speaking, are incorporated. Most of them are incorporated provincially. So whether you're a charity or not has more to do with the tax law, has more to do with trust law. Charities could be incorporated provincially or they could be not incorporated provincially. What ONCA cares about is where are you incorporated. So the answer is yes, it applies to nonprofits provided they're incorporated provincially. Yes, it applies to charities provided they're incorporated provincially.
Thank you.
Okay.